When parents separate and divorce, grandparents sometimes get caught in the middle, and opportunities to spend time with their grandchildren may be restricted by one or both parents. In those cases, if grandparents don't become legally involved in a custody case, they risk losing all rights to see their grandchildren in the future. To address concerns about maintaining the special bond between children and their grandparents, the North Carolina Legislature enacted laws that specifically address the rights of grandparents in custody cases. One of those laws permits grandparents to intervene, that is, to become parties to a pending custody case, so that they have a legal and enforceable right to visit their grandchildren after a divorce. In North Carolina, when an intact family exists, no other person, including a grandparent, may intervene to ask the court for permission to see the child over a parent's objection. After a judge has made a final decision about child custody and visitation, the child is legally considered to be living with each parent in an intact family. Under the law, single-parent homes are considered as intact as homes in which both parents live together. Therefore, when parents of a child are separated and a grandparent fears that one or both parents may prevent the grandparent from having a relationship with the grandchild, the grandparent may wish to intervene in an initial custody determination. This would occur before the court's decision on custody. The grandparent would ask the court to establish custody or independent visitation rights with the grandchild which are not dependent on the goodwill of the custodial parent. When a grandparent moves to intervene, the court must decide whether a substantial relationship exists between the grandparent and the child, and then whether it would be in the child's best interest to order that a grandparent be allowed to spend time with the child. If a grandparent fails to intervene in an initial custody determination, a grandparent may still have an opportunity to intervene later if one of the parents asks to modify the initial custody order. A grandparent may file a motion to intervene in the modification case, asking the court for permission to become a party to the suit so that he or she may seek custody or visitation rights. Grandparents have a right to intervene in such cases so long as the case is pending. In a handful of North Carolina cases, grandparents lost their right to ever visit their grandchildren after a parent died following a final custody decision, where the grandparents did not intervene. The surviving parent did not want the visits to occur. Under the law, the surviving parent and children constituted an intact family. The court has generally held in those cases that the grandparents had no right to intervene and the court no longer had jurisdiction to allow the grandparents to do so. In a divorce situation, grandparents should consult an attorney with experience in grandparents' custody and visitation rights to determine the best course for protecting that special bond with their grandchildren.